Good afternoon, Dr. Kanagaraj. My name is Yong Ashishan, and today I'm going to be presenting my land law assignment on this Latin phrase by the name of sujus est solem, ius est usque et colem et ad inferos. According to Cooper Adams, this Latin phrase means that whoever owns the land owns everything above and below it. However, this principle is now limited. Landowners may only control the airspace and subsoil necessary for reasonable and enjoyment use of their land. The Latin phrase expressed three-dimensional concept of land ownership in English law. According to Eric R. Kale in 2013, the maxim remains doctrinally important, but is no longer accurate in defining proprietary rights today. The courts have limited airspace rights to a height necessary for ordinary use and enjoyment, as opposed to as seen in the case of Bernstein v. Skyviews in 1978. Still, Parliament has limited the maxim's downward reach by vesting petroleum in the Crown Petroleum Act 1998 and allowing compulsory mineral access. The Law of Property Act 1925 defines land as the land itself, any structures that may be built on it, as well as fixtures, minerals, mines, and the airspace surrounding it. In reality, what is the extent of a landowner's airspace and the rights in the subsoil? Now, let us talk about the maxim's first limitations, as it arose in airspace. The maxim "sus est solem," as applied in aviation, was a renowned article written by a man named Yehuda Abrahamovich in 1962. He stated that the previous regulation is only applicable to the low airspace that is generally usable, such as for a house or a tree or many more. The sky is a public highway for aircraft, and everything that is elevated is akin to a road. This implies that public aviation is prioritized over private aviation. Trespass is not committed when an aircraft flies at a high altitude and does not cause any damage to their property. This is supported by the Civil Aviation Act 1982, which section 676, subsection 1, stipulates that an aircraft may travel at a reasonable altitude without incident. Therefore, what is the maxim? It is not incorrect, it is merely restricted. In Kelson v. Tobacco, 1942, a sign projecting into low airspace was held to be a trespass, reflecting the early literal meaning of ad colem. However, in Bernstein v. Skyviews in 1978, Lord Justice Griffith held that ownership extends only so far as is necessary for the ordinary use and enjoyment of the land, right? According to Gray and Gray's Elements of Land Law in 2011, the modern viewpoint states that landowners maintain control rather than the complete ownership over the upper space. As Doran in 2020 observes, this practical method remains highly useful today, particularly due to the growth of aviation and the increasing adoption of the drone technology. This adaptable Bernstein approach remains highly pertinent in the current era, given the aforementioned increasing use of drone technology. Drone flights at approximately 50 meters or 164 feet did not constitute as trespass in the case of MBR Acres and Curtin in 2025, because they did not disrupt the ordinary use and enjoyment of the land. This has been directly applied in recent High Court decisions. However, in the case of Anglo International and Persons in 2023, it issued an injunction against drone overflights due to the fact that drones were flown at a low altitude, which allowed for the comprehensive filming of the site and the facilitation of additional physical trespasses. This demonstrates that low altitude or intrusive drone use can still be considered trespass in the appropriate circumstances. Now I'll be talking about the maxine's second limitations, which arose in the subterranean side or ad inferior. In subterranean limits of land ownership, Ira G. Stevenson contends that the common law maxim granting surface landowner rights ad inferior is restricted to depths that are reasonably accessible and usable for surface enjoyment. He proposes that no ownership extends beyond these depths, as absolute subsurface title would be inconsistent with public policies and practical realities. For example, the surface proprietor is not granted a propriety claim over deep caves that are inaccessible. Instead, rights are limited to the prevention of unreasonable interference rather than the assertion of dominion over unutilizable subterranean features. Morgan contended in Digging Deep, Property Rights in Subterranean Space, that English law before 2010 exhibited incoherent restrictions on subsurface depth, resulting in doctrinal disarray about non-mineral access. Although the Crown held ownership of critical minerals such as petroleum in the Petroleum Act 1998, the emergence of deep infrastructure such as fracking and carbon capture presented significant challenges such as trespass risks over vast underground emissions. The ambiguity resulted in the case in Bocado SA v Star Energy in 2010, in which the Supreme Court confirmed that surface owners retain trespass rights underneath their land, even against Crown licensed enterprises in the absence of consent. Now I'll be talking about the case of Bocado v Star Energy United Kingdom Onshore Limited in 2010. In this case, Star Energy drilled 3 deviated wells beneath the claimant's land at the depths of 800 to 2,800 feet to access licensed petroleum reservoirs. Despite holding a Crown license under the Petroleum Act 1998, the company had no consent from the landowner. The Supreme Court unanimously held this constitutes as a trespass, affirming that a freehold title includes subsurface strata unless statutorily excluded. However, the damages were limited to a nominal £1,000, with Lord Brown emphasizing that any compulsory access should be accessed under the Mines Working Facilities and Support Act 1966 framework, balancing private property rights with the public interest in regulated resource extraction. However, the academic reaction to Bocado is mixed. Morgan in 2013 acknowledges the decision to restore doctrinal clarity on subsurface trespass, but contends that it does not satisfy the requirements of contemporary deep energy infrastructure, including carbon capture. In the Cambridge Law Journal in 2011, David Pearce criticizes the ruling as a formalistic reassertion of suit as solemn that may prioritize private property over efficient public resource use. He observes that despite the clarification of trespass liability, the practical incoherence of compensating surface owners for deep strata they cannot realistically exploit remains unresolved. Both scholars agree that surface proprietors maintain legal title to deep strata. However, their practical control is significantly restricted by modest compensation mechanisms and statutory licensing regimes. Section 43 of the Infrastructure Act 2015 provides an automatic right to use deep level land at depths of 300 meters or more for the exploitation of petroleum or deep geothermal energy in land areas, provided that a proposed payment scheme is submitted and 14 days prior notice is given. The payment scheme is voluntary with a statutory fallback in the event of failure. This statutory override directly reduces Bocado's practical influence in deep energy circumstances. Vertical ownership is significantly restricted by contemporary legislation. Courts may authorize third parties to construct infrastructure or work minerals beneath land without the landowner consent under the Mines Working Facilities and Support Act 1966, provided that compensation is paid. The Petroleum Act 1998 vests all in situ petroleum in the Crown and authorizes the Secretary of State to issue extraction licenses, thereby excluding surface proprietors from control. In conclusion, this maxim has symbolic meaning but no practical applicability. In Aspanes, Bernstein limits proprietary rights to a height required for ordinary use and enjoyment. In Subsoil, Bocado confirmed that the freehold title extends to deep strata and the unlawful deviator drilling is trespass. Thank you.